before we jump into the actual nuts and bolts of a trial, do you mind just laying it out from beginning to end?
What, the trial?
The trial.
So you get there and you're like, why the fuck did I go to trial? No. No.
You're not
So
excited?
you get like all your blood taken, all your blood. You're like you get in there and you start sweating bullets. First thing you know, you get sent out. See the preliminaries. So you do your Sandoval and your Molyneux.
What are those?
Anything else? So your Sandoval is your past crimes that can be used against you.
Okay.
Usually testify.
Yeah, justify. Yeah, and you said we'll get to them later, but what happens is usually you get to a Sandoval compromise, and we'll talk about later. Molyneux is the crimes, past crimes that you've been charged with, that can be brought under certain things. I call them mimic. There's certain things that you can bring them out, and then after the preliminaries, then usually if it's a jury trial, it's the difference between a jury trial and a bench trial. You start doing what is called voir dire. That is called jury selection. Judges say this all the time, and I agree with this. It's actually jury deselection. You deselect the jurors that you don't like. Then you do what is called an opening statement.
We love you all, jurors.
Yeah, we do.
We do love you.
We love you all, but some of you just are not qualified. And then you do
For
what
my
is called,
jury.
Yeah, for my
My
case.
case.
You're not good for
you're
my
Go
case.
for another case.
You're a great
for
You're
civil.
good
For civil. So what you do, you go
great guy.
through opening statements. Opening statements, the defense doesn't have to do one. Actually, I like doing one.
Defense doesn't have to do anything.
Exactly, defense doesn't do anything. We'll get to that later. And then you go through the prosecutor's witnesses. They can call whoever they want. I always say that the prosecutor's case is, they're the chef. They actually cook their meal. They put whatever ingredients they want. They want to do whatever they want with it. At the end of the day, it's their meal. If it tastes like shit, throw that case out. You do, after the end of the prosecutor's case, you do what is called a trial order dismissal. And then it's up to the defense to put on their case. They can call witnesses. This is the time where if you have a client who wants to testify, you have to talk to them, and you depending on your defense, self-defense, you might want to turn to your defense. Based on that, the client may have to testify, may not. You put the client on, then after that you have to do a trial order dismissal. You have to do these two things because they're important for appeal. And then you'll do the summation, which I think I said 85% is jury selection. I think I have to say that 15% is how you hammer it home. You have to have a strong ending in order for the jury to come back. But before that, you speak to the judge about the instructions, what you want, the instructions of the law that you want to be conveyed to the jury. And after that, the jury goes to deliberate.
And it's just a waiting
And
time.
there's a waiting game, and the jury can come back with notes telling the stenographer to please read the minutes of this witness, or can you instruct me on this and that. But from the moment you sum up to the moment that the verdict comes, it's a waiting game, and it's a terrible waiting game. I hate it. It's the worst part of the trial.
You're literally on call.